And if I had to be another person to stand up, if I think, after really going through this, and looking at the files and looking at the case, if I really feel that Karen Reed didn't do this and I have to be a voice that stands up and helps, I will.
We're expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
We're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Now, just be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
I'm going to tell you one thing. Karen Reed's not going to fold. Karen Reed's not going to give up. Defense team's not going to quit. The Free Karen Reed movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Believe me. Oh, yeah. What's going on, everybody? Welcome in to Let's Talk Live here on the LTL Media Channel. It is Friday night, and we have a fantastic show planned for you. I have attorney Nan Gallagher back here live on the show to go through the most recent Karen Reed hearing that we had the other day. I am your host, Brian. Some people call me BLT. A lot of people call me LTL. Some other people have some other choice fun words for me, but you can call me whatever you want. And we're going to hang out here tonight and go through this hearing. I think I just have permanent sinus infection. I think I have permanent laryngitis. This sucks. I've been like this for 3 weeks. I'm absolutely pissed, and I can't get over this damn thing. But we're still here. We're having fun, and we have a lot to get into this evening. I'm not going to wait too much longer. Oh, really quick, before I bring Nan on, just want to make sure that everybody's kind of aware of this. If you have been noticing, I've been kind of cutting up some of my shows into mini clips and posting them. I'm going to try to do that on Fridays. So I may post a clip and do it as a premiere so you can come in and have some conversation about that if you haven't seen that clip, if you haven't seen the show live. So I'm going to start breaking up some clips and posting them. It's been really productive here on the channel. And it's, the clip that I dropped of Nan today literally brought in like 40 new subscribers. So welcome in new subscribers. And I want to keep doing that because it's been productive for the channel. Anyway, I'm not going to wait too much longer. We're going to bring Nan on the panel here. She is backstage. Oh, Nan Gallagher back live here on the show. How are you?
I'm great. How are you, Brian?
I'm well. I wish I had a little bit of a voice here, but
oh no, I'm
just
enjoying
can't shake
it.
This thing.
I am enjoying spending a Friday evening with a sultry, raspy voiced man. I know there's probably people in your chat who would agree. So you ask me anything you want, Brian. I'm all yours because I love the voice.
Look at this. We have someone new here. Look at this. I'm new. Thank you. Well, thank you for being here, Kokomo. We have a fantastic chat. Feel free to interact with the chat. And I think I saw one of my moderators, Lauren. She has the flu right now. Oh no, Lauren, I hope you feel better. Listen, I was knocked down for like almost 2 weeks. And I still can't get rid of this damn congestion. But anyway, we're here. Nan, what did you think of this hearing the other day? And I'm going to throw some talking points out to you here, and so I have my notes up here. So I feel like there's some maybe potential Brady violations going on.
That is
And I know that we talked about, we kind of talked backstage about the Alec Baldwin case. We saw Hank literally throw Lally under the bus about discovery in this case. So you have that inner fighting going right now. Also, we heard about the Brian Higgins phone call again at 1:30 in the morning. And also, I really felt that Bev at the end of this hearing really has a hard-o to get this thing started on April 1st. I'm going to tell you right now, February 11th is the deadline for the defense's motion to dismiss. I already know her answer on that. And I think you do too, Nan. She's going to go, nah, we're going on with trial. So what did you think the other day? And we'll pull this up and go through it here in a second, but I'd love to get your initial thoughts.
First, I have to ask, maybe it's a local thing, but I heard the word hardo in your questioning. So we say it a little differently here in New Jersey, New York, but I love that. So anyway, what did I think? Well, first, let me set the stage for your audience. I was, I guess that was yesterday, Thursday. I was in court.
Okay.
And for people who have questions about that, like I'm not streaming while arguing motions myself, but I was in court waiting for a hearing. So I have my one AirPod in, and I was very impressed with Alan Jackson's arguments. I was completely almost fell on the floor with many of Hank Brennan or Spanky. I use those terms interchangeably. And for anyone in the chat, you can feel free to throw new suggestions my way. By the way, yes, I'm hi Letter Rose by Bettero in the chat. I have a rapport with her because we're Bergen County, New Jersey chicks. But anyway, so I thought the arguments that the defense raised were great. It's always wonderful to see things live and in action. And, to some degree, I'm watching it. I'm listening to it and not watching it. But I have to say, I am not ultimately surprised with Judge Cannoni's decision, although I think she made the wrong decision. And I know that several lawyers have different views on that, and different people on the social media channels have different views on that as well. But ultimately, I pick up the little socially relevant pieces of this where, Hanky Panky Spanky is playing with pencils and he's making comments about so-called experts, and he's making comments about, the defense had 3 years to ask for this. I know that will come out in our discussion tonight, but that is a load of put in your poop emojis, everybody. The defense didn't, quote, have 3 years to ask for certain materials. And I don't want to bore your audience with a lesson on what the Brady case means, because I know you're all watching, so you're all smart enough to have an understanding about the fine essence of it, which is that the prosecution has an affirmative duty to hand over, without being asked, by the way, exculpatory, inculpatory evidence that can prove or disprove culpability, or anything that would be and could and should be used to impeach witnesses. You could check all those boxes as far as I'm concerned, in terms of prosecutorial failures. But for the special prosecutor to come up in front of the court and to have such an outright disdain for the fact that he even had to oppose and argue that motion, the opposition that is, it's laughable to someone like me, because it was a very properly filed motion. But as I had said, as I had said on social media last evening, I saw lots of Easter eggs in the defense motion and the argument. And for anybody, and we'll get to it, Brian, but for anybody who had, who's watching it and saying, wow, AJ coming in hot, this was fire, it was great. That's true. But he was paving the road for his motion to dismiss. And it was incredibly intentional, the backdrop that he laid in his argument. He wasn't just going to say, hey, we wanted to get this guy in from Arizona, and, you know, the prosecution hoodwinked us and we want our money back. It was designed to, as I mentioned to someone else, to be an amuse-bouche for what is yet to come. And I am here for it. So kudos to AJ, even though the motion didn't go his way. I think it should have. Other learned counsel say, nah, maybe this was the right result.
Yeah. And then we just found out, which was really cool. I know Nick Rocco was posting about it. That $12,000, they literally raised all that money back for Karen through her defense website in less than like 24 hours. So they got the money back anyway, which was fantastic. I think there was like the highest donation I saw was like someone made a $3,000 anonymous donation. That is so cool that people are just, you know, so in tune with the innocence of Karen Reed. I mean, it's almost, I just say like a blind man could see all of this. I mean, I don't understand. I don't know why the jury didn't see it this first time around. I think they were just flooded with so much BS from the Commonwealth that it just kind of malaised them through this. I think they just got bored at some point and checked out. I mean, I saw it when I sat in that courtroom, that I would look over to the right-hand side and it really, like, Lally's talking and there's like half the jurors are all checked out. And the minute AJ gets up there, everybody's just pinned and watching. And it kind of gave me a false sense of security because it was like, oh, defense got this. Karen's going to walk out. But you really never know what's going on inside juries' minds.
You know, Brian, I agree. And Brian, I just want to make 2 points about that raising of funds to recompensate Karen and for the cost to bring Mr. Erickson out.
Mm-hmm.
One, despite some speculation, I was not the anonymous donor. So I just want to set the record straight for some people. I'm not that rich, folks. No, but no. Two, I know that another streamer might have thought that I helped raise that money while I was on a different creator's channel last night. I know I was not part of that at all. I'm so happy that that was the case. And as I started to see that they were trying, the team, the movement was trying to do that, I was actually completely busy and occupied.
Yeah.
And by the time I found out that they had raised it, I was on a stream and I went, oh my God, I'm so happy, because that's a big FU to the other side. In fact, I think that might have been written somewhere in the anonymous donor's message, as far as I'm concerned. But yeah, it's pretty unbelievable.
And then I think I saw something drop today that the Commonwealth has now hired a specialist meteorologist. Okay, we're gonna find out about snow and rain and all that fun stuff, I guess. Weather.
Can I just? I mean, look. Let's be real, folks. Okay, there are ways. First of all, understand this: experts are needed to explain things to jurors that are outside of their knowledge base. The actual term of art is outside of the ken. Like a Ken doll, outside of the ken of the average juror. This is not a weather case. It is not a weather case. And I saw someone post something on social media like, if we're going to be calling meteorologists and some other specialty to refute any of the defense's arguments, you're losing. You're losing if that's important to you. But also, I mean, there is video evidence. There are online records that show what the weather was. I mean, everyone would understand when the weather really started to accumulate. It's not a weather case. And honestly, if they want to call a meteorologist, bring it. Because as far as I'm concerned, it does not take an expert to tell me, and it shouldn't take an expert to tell a jury, that more pieces of taillight would have been found in less snow. it's it's very relatable. Would you find more taillight pieces with however many feet of snow had fallen? And would pieces of taillight just keep revealing themselves for days and weeks to come as snow melted? So I hope they sick a lessee on him, because he seems the most kind of scientifically geared.
I'm sure he will. Yeah.
And he'll find a way to make weather interesting.
Oh, yeah. Yeah, he's going to go, it was snowing. We get it. I just want to get to this. Mama She 13, thank you for the $10. Says, Ugh, I'm so late, but I love seeing Only Nan in all of the best places. Thank you so much. Want to get to this. Piney Woods, thank you for becoming a new channel member. Heatherlicious, back to the membership group. Thank you so much for the support. And Bodega Lady is a new member as well. All right, Nan, let's oh, my voice cracked.
You sound like Peter Brady.
Oh
from
my God.
Are you wait, you're around my age. Yeah, Peter Brady, when his voice cracked on the Brady Bunch.
Change.
I love it.
You know what episode I love the Brady Bunch? The one when Greg, he put the sheet up and was forecasting the UFO thing.
Yes.
Using that little the friggin' the kazoo thing, and they thought that it was a real UFO. And I think like the Air Force actually came out and investigated. And he's like, no, it was just really me. It's not a real UFO.
Well, it's funny you bring that one up, because the Air Force came out to investigate that. We can't get proper military forces out to investigate
all the drones.
freaking drones. So, and by the way, there should have been drones out on January 29th, 2022, inspecting that crime scene, because that machinery would have done a better job than the Canton PD and the MSP.
You know what's crazy? And before we get to the hearing, I just watched that 4-part series on Netflix about the O.J. Simpson trial, and I urge everybody to watch it. If you have Netflix, it's number 1 on Netflix right now. It's 4 parts, about 6 hours of viewing total. Well worth it. And they go through all of the evidence that wasn't brought in or submitted to trial. It literally would have convicted O.J. Simpson probably about 5 minutes. But there's the part where they talk about the evidence collection, and they spend a lot of time on this. And they said Bailey, and I forget the other attorney, because there was so much footage of them filming that crime scene of the media, all the different angles. And what they did is they went back and watched video of the evidence collection. And when they had that the forensics expert, and I think his last name was Futch or Fooch.
Yeah.
And they literally would be like, so when you picked up, let's just say the glove.
Whatever,
okay?
without
when you picked up the glove, were you wearing rubber glove? Were you wearing protective gear and rubber gloves when you were collecting this evidence? And he's like, yeah, of course. Oh, really? And they literally would show the tape. I urge, if they haven't thought of this already, Alan Jackson, David Yannetti, Karen Reed defense team, go back and show in these videos the way that they were collecting evidence and the way that it was tainted, and make it a stronger point this time around. Show it, bring it to these people, and nail them on it, because that really was a big turning point in the OJ trial. And I found something out about when they collect blood in vials, or what they were collecting in vials. There's some, it wasn't like a plastic, but there was some additive in it, and it literally was like tainting the evidence. It was crazy. But I urge everybody to watch it. It's a really great documentary. Sorry.
I need to agree wholeheartedly. And I think it's so relevant to this discussion, because when I look at the Karen Reed case, I harken back to the O.J. Simpson case.
I'll never parallels there.
And maybe all of you who are old enough remember where you were when that verdict came down. I'll tell you where I was. I was a sophomore in college at Fordham University in the Bronx, sitting down, and they stopped my Spanish class, and they were like, oh my God, the verdict's coming in. And I remember, at that point I knew I was going to be a lawyer. I wanted to be a lawyer. And I remember that verdict came down, and I was like, oh, so upsetting because I was already looking and saying, this is enough to convict someone.
Yeah.
But I can't agree with you more, Brian, in terms of giving some unsolicited advice to Karen's team. I think there was a tremendously effective use of pointing the finger at police ineptitude and misconduct in that case. The thing with the were you wearing gloves when you picked up the glove, etc., which is very visual and very just extremely literal. People get that, and it's common sense. And in the jury room, any lawyer will tell you guys this. We want you to bring your common sense. And that is one of the reasons also why I do think next time around, there probably should be less educated jurors, the ones who aren't going to try to solve it on their own and say, well, I don't think it was this, and it wasn't driving, 60 feet at 24 miles per hour. Like, I think if they try to figure out this mystery that very learned minds and very commonsensical people can't figure it all out, if they try to do that themselves because they think they're smarter than everybody, it's going to create challenges for them. So I am going to watch that. So thanks for giving me more work to do this weekend.
And it's like, wasn't admitted in evidence. And it's like key things, like key pieces of it. And you're like, you got to be kidding me. It would have literally convicted him in 5 minutes. But I think that would be a great focus this time around, and use those words with this jury. Contamination, police procedures, a great chat right here. Letters to Bettero. I think it would be huge if the defense brought in someone to talk about police policy and procedure. And Nan has been talking about that on all of these channels. And I think they probably will this time around. They'll have an expert.
Brian, I got to say one last thing on this, because your audience here, maybe some of them aren't working tomorrow and this weekend. And for those of you who are, kudos to you. And I have a lot of respect because I will be. But
I will be.
Think about the OJ case for one last thing. There was a perceivably villainous law enforcement officer. Furman. Now, right? You know what, Brian? We should do a show. I know this is your channel, so please.
Yeah, we could do a cross comparison. Absolutely.
Yeah. Let's juxtapose two a-hole cops who completely messed. No, I'm kidding. Let's juxtapose them and see if there's some similarities, because it is my opinion as a lawyer that the Furman aspect is what primarily tanked. It tanked the case.
Yeah, it did. When the tapes of the N-word came out, that's it. And that was the brilliance of that defense team, Johnny Cochran. Well, guess what? And you go out to the media and say, this is a case about race.
Yep.
And that was the flip. And that just blew the whole case wide open. But anyway, I digress. I digress. We're going to get on this, and I think we should do a cross comparison. They'd be great. All right, let's bring up this. My voice is so bad. Let's bring up this hearing. And we'll go through it here. Hang on one second. I'm going to bring us
for my glasses.
Yeah.
I think I need glasses to look for my glasses.
You need glasses for your glasses?
Yeah.
Yeah, we'll go here. We'll bring us to the side.
Okay.
Yeah.
But
I'm going to go on record. OJ totally did it. Totally did it.
Agreed.
You had some a-hole cops. You had terrible policy procedure, but there was so much overwhelming evidence. And I'm telling you, if you watch that series, the evidence that wasn't brought in or even talked about from well, I don't think it's a Commonwealth there, but the state, oh my God, you're like, they didn't bring that in. That literally would have convicted him in 5 minutes. But anyway, great. You gotta check it out. All right, here we go. We're going to get AJ up first. And I will boost this. Let me bring him up. Here we go. Lisa says he's guilty as fuck.
Love it, Lisa. By the way, here's a challenge to your audience. Everybody listen to when Brennan argues or whatever you're going to show, Brian, and ask yourselves if you think he's going to be well received by a jury.
Yeah.
Okay.
It was erased by an operation of automation.
Anytime you want me to pause to comment, please just say pause so you can comment.
Okay.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address
Excuse
our
me.
concerns are in my oral statement.
All right, I hear
The
you.
court, may I?
Yes.
The court started by asking, what is it that the defense is asking for? Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that
Real quick, I just want to make a point, and I had this in my notes, and I don't want to get on Peter Tragos at all. Lawyer, you know, he's great. It's fantastic. Breaks things down amazingly. Okay. I was watching his video when he broke down this, and he talked about when, and we're going to hear about it here, when Jackson called Brennan to have their expert come out and copy that DVR. And he said, you know, Brennan really didn't need to do that. And he said, I don't really agree that they had to wait for the expert to get out there, because it should just be, you know, shared discovery with the defense anyway. Here's the only pushback I have on that. And Peter doesn't know. Peter doesn't live around here. When you live around here and you're immersed in what's going on, and you know about Sandra Birchmore, and you know about Enrique Delgado Garcia, and you know about Just en Route and all the other cases that go on here, okay? You cannot trust any of the police departments around here in this very moment. So yeah, I would want to wait. And yes, I would want my expert to be there before anything is extracted. And then what do we find out? That a full extraction is on some iCloud account of some retired sergeant? Like, how does this happen? So that's exactly why, you know, the expert should be there when any of this digital forensics is being captured or saved or downloaded. Just like when they did the telematics system, they're like, no, we want our expert to be there, because there's been so much manipulation in all of these cases. So again, you know, Peter doesn't really quite know the vibe around here. And I'm not pushing back. I think he's brilliant.
Right.
That was only a little bit of criticism I had about what he said. But it's not like bad criticism, just like, no, we need to have the expert there.
Yeah, I mean, I love watching Peter. I think he's great.
It's great.
And he was a prosecutor, and he's the son of a state and federal prosecutor, former prosecutor. But you're right, Brian, because once there becomes a significant and meaningful question of the transparency, authenticity, chain of custody, the Houdini acts, the, apparating, the producing something after you say it doesn't exist, and then in the middle of trial. Once all that happens, then there has to be this level of, don't do a damn thing. I'm gonna get in my plane. We'll be right over. And I do wish Alan Jackson would have emphasized that a little bit more in his argument. And I do think the judge probably still have denied the motion. I thought she was going to deny it. I didn't think she should have, but that would have resonated with most judges, where they say, this isn't your standard. Well, we don't have to do that. We don't have to wait. You kind of should in this case. And for somebody like Brennan, who's going to go and say, I'm going out of my way to hand them over things that they're not even entitled to, because I'm, the titan of transparency. I sit there and go, you know what? Stop giving yourself sainthood. All right. You should be handing this stuff over, because your predecessor, who's pushing pencils and eating cheese sandwiches at the table with his head down, playing solitaire on his phone, didn't hand the stuff over. These opinions are my own, by the way. So,
yeah, I mean, clearly didn't. And then the only way for Brennan to build his credibility was to throw Lally under the bus. I mean, he basically had to do that, because there was so much botchness, with all of this. I mean, look at, like here's a good, Peter was just saying that the Commonwealth doesn't have to allow it. Not should the Commonwealth allow it. And, we just made our point on that. But here's another great point. Riz says, can't trust anything the Commonwealth. Look at the sallyport video. Exactly.
I agree. And honestly, if I were Canoni, she knows that there were these stupid antics during trial 1.0. So
Yeah.
she loves to say this is a new trial. It's a new trial.
Yeah.
But now that she knows and has the historical knowledge base, and trust me, she knows that was wrong. Half the antics they went through, they put the defense through. She should have put into place, and I don't know what it would have been called under Massachusetts rules, but she should have put into place immediately at the recommencement of a second trial, this ain't going to happen again type of rules. Like if you don't produce it by this date, it is barred. I mean, even just the simple little things like, what's his name? The Titan of transparency. Oh, Brennan, whatever his name is. Yeah. He was supposed to hand everything over by February 5th. He was still handing things over by February 6th.
Exactly.
Deadlines matter. And you're going to all start to see in the next 30 days plus, there's going to be more stuff coming from the prosecution. And there's going to be things like we're seeing with Allen and the defense team, like, we need more time, Judge. We need more time. Yeah. And Judge Canoni, with all due respect, needs her weekends too. Don't we all? So, she's keeping the defense on such a short timeline. To the onlookers, it is unfair. And, to the people on the other side of the aisle, from those who support the Karen Reed movement, we're all kind of saying to ourselves, this isn't fair. One last thing, think about it. The defense has only a small window of time to react with experts and documents and evidence to what the prosecution just produced. So the evidence is what it is, but they have to get, wait, do we need a meteorological expert? Do we need this type of expert? They have a short timeline to do it, but the prosecution presumably has had since the day that Karen had her mistrial until February 5th, when their certificate of compliance was due and the rest of their discovery. They've had months to do all this stuff. So it is inherently imbalanced. And most reasonable judges, in my opinion, would give the same amount of courtesy, maybe not equivalent, but a very similar amount of time to the defense to provide their responsive discovery.
It's a crazy case, and we keep finding out more and more and more that the Commonwealth has done to really stifle the truth in all of this. All right, let's listen to AJ here.
Body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amber scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018.
I'm very familiar with the case.
With Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is, and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed.
Love it. Getting it on the record. Getting it on the record. Brady violation, Brady violation, Brady violation. I love it. Get it on the record.
I agree. And I was just going to ask you to pause right there to say, part of what he was arguing there has no relevance to the fact that she expended 12 grand to fly an expert out and to give him travel and accommodations. So, he is literally paving the way towards prejudice. In this context, that's legal prejudice, harm to her. Her position is harmed. Her defense is harmed. She gets and has, as do you all, which is why I wish more people cared about this case. And it really warms my heart to see that more and more are starting to, especially through content creation. But more and more people need to start seeing, well, wait a minute, if I were that defendant, would I have to expend money for this? Am I going to have, GoFundMes and fundraisers to help me? What if a prosecution and the government and or police were doing certain things like this to me? And take out of that question the third party culprit defense, even if it was just, I'm on trial for murder. It has nothing to do with police wrongdoing, but there's missteps and late produced evidence. And, suddenly an expert has to fly out and something that they should have known wasn't there, isn't there. And one last point on this. I've seen a lot of banter on social media about this where people who believe in Karen's guilt say things like, well, Jackson conceded that, he might not have, or he was ready to admit that the data might not still be there, but still sent his expert anyway. And that's on him. That's professional misconduct. No, it is not. Because of what you were just saying, Brian, which is, with a history like this, who's going to trust you folks? So yeah, I wanted my expert there. And B, because it is, and he says it several times, it is a self-executing duty under Brady to provide everything, whether Alan asked for, and I'm saying Alan, I also mean Yannetti, Alessi, whether the defense asks for it or not, whether the defense calls you or not and has any banter and saying, I don't know if it's still going to be there or not. So this kind of side conversation that seemed to be relevant in Judge Cannoni's decision, and if you've all read her order, which is short, it seems to have mattered to her that, well, Brennan said this and Alan Jackson kind of agreed, so no, I'm not awarding fees. That is not, in my opinion, any way relevant to the decision. The minute Alan expressed a desire to have his expert review the original, and I'm not a techie person, but the original raw footage and/or system, Brennan should have gotten off of his chair, stopped sharpening his pencils, got himself over to the police department or wherever this system is, and checked with people who can check to see if the data was there. That should have happened and it didn't. It's a foul in my book and it leaves a huge bad taste in my mouth, and I will actually be louder and more obnoxious that he took that position in court yesterday.
Yeah, and that was my point. I know someone was just giving me some pushback in the chat about the lawyer you know. I know that he's pro Karen Read. I 100% know that. Yeah. The only criticism I had is because he said that allowing the expert to come out and do that, Brennan didn't have to do that. But I was saying in the stance of, if you live here in Massachusetts and you look around at all the things that we cover here, do you think that you really would trust any of the police departments around here right now with handling evidence? No. That was my point in all this. And the thing is, Peter's not really around here, so he doesn't know Enrique Delgado Garcia. He probably doesn't know about Sandra Birchmore. That's what I'm saying. All these entities are involved. Yes, I would want my expert to be there. That was my only critical point. And that was my only criticism. And it really wasn't bad criticism. It was just kind of like guiding him a little bit, saying like, dude, there's a lot of corruption around here.
Oh, I agree. And I agree with your sentiments about Peter. Like,
I love Peter.
As someone with my background and education, I like him. I like listening to him very much for his kind of very concise encapsulations of things. If I really want to laugh my
Right.
ass off, I listen to Emily D. Baker.
Yes.
But the two of them, as your audience will probably recall, they both approached trial 1.0 blind. They didn't have any real backdrop.
We did. Yeah.
Yeah. But you're right. I think he's right in that Brennan technically does not have to give such a courtesy of how this data is extracted and provided. But this is Massachusetts, or this is Canton or Dedham, whatever micro
everywhere around here.
Yeah. I'm gonna have to hire a bodyguard when I come up there.
Letters to Betterow says, lawyer No has seen it all, so it shocks me that he would expect the defense to trust the Commonwealth after he has witnessed in what he's witnessed in this trial. And that was basically, thank you. That's basically what I was trying to express in all this. But I don't want to get hung up on it too much longer. Let's try to play through a little bit.
The court knows is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these sallyport videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
When Unetti filed the preservation.
Right. On
Days
February
later.
2nd, February 2nd.
Yeah.
And by the way, that's good lawyering. And Unetti didn't even have to do that. Like that is exceptional, very proactive lawyering. But the mere fact that Brennan didn't know this, I don't fault the judge. It doesn't seem to be in the judge's file. She probably should have checked, but Brennan should have known. So it would behoove the prosecution for the new special prosecutor to actually converse with the old prosecutor on this case, instead of them just sitting next to each other at a table, ignoring one another, because a lot of this stupid banter could have been avoided. It clearly happened in the beginning of February, and it's binding on this court.
Mm-hmm.
So we'll see what happens.
Do you know that Karen Reed's SUV sat inside the Canton sallyport for almost 3 days before it was processed by forensics? Do you know that?
I did not know that. Yeah. How do you
go back and look at the PCA and you read through it? I think it was like 3 days before they actually had the state police crime team come in and start processing that vehicle. 3 days it sat there.
So question for you, Brian, and I don't mean to put you on the spot,
sure.
but presuming that's true, I remember seeing pictures presented at trial of red Solo cups in Stop and Shop bags in the sallyport near the murder weapon. And I think there was even commentary that, well, what is that? That's melted snow, right? Yeah, that's, somewhere they were commenting on the appearance of the bags. I'm wondering if that biological evidence itself was processed for three days, or when those pictures were taken.
Seriously.
This is it, crime scene messing up for dummies. They should, make their own book on it.
Yeah. I got to go back, but I can remember reading through that PCA, and it's like, I was like, it took them almost 3 days to start processing the murder weapon that supposedly killed a Boston police officer. You're waiting 3 days to process his car. It doesn't make any sense to me. That would be like in my playbook, number one, let's get in there and start processing this thing.
Well,
Crazy.
you know my personal opinion now that I know that, and I'm going to read the PCA now, but now that I know that, I'm sure they had no rush because the taillight had been broken by someone on the inside.
They haven't smashed it all up yet.
Yeah. They're like, oh, we got all the time in the world. We're going to invert or make a video disappear.
Right.
We're just going to make it all go the other way. This is ridiculous. Like I don't want to curse on your channel, but
So
this
go
is
for it.
complete mind fuck. I'm
Yeah.
sorry. Like gaslighting at its finest. So
Crazy.
yeah, let's
go. Let's hear AJ.
Asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons. Two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, the prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8, subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, within their own time frame to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the sallyport. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the sallyport. And we got that one after the trial started, in the middle of trial.
Brian, can
Yes,
I
ma'am.
just ask you to pause for one moment?
Yeah, absolutely.
Just wanted your viewers to really understand what he's getting at here, because the piece of video which was produced days before trial, then an inverted video, which by all accounts is inverted, and nobody can convince me. I don't even think the prosecution can convince itself that it wasn't messed with, because of, the time stamping is forward, but the video's inverted, and all of the reasons that video Jesus or whatever her name is set forth on the Young Jerks, which everyone should watch. That was a really interesting.
Yeah, it's fantastic.
Way above my head.
Yeah.
But what Alan is getting at is, but if these videos were produced right before trial and during trial, then there was something else that was produced in July of 2024. Then it all existed and was all preserved at some point contemporaneously in time to the incident in question and saved somewhere. And I don't believe, although I defer to people who are technologically savvy, which I am not, I don't believe that whatever that data is in whatever form from whatever system is in its raw state up on some iCloud somewhere by some inept retired detective. I don't even, and I think I saw somewhere, although please don't quote me on it, that the type of data that it is doesn't like correlate to iCloud related storage. So definitely follow people who know more about that than I do.
Yeah, in this, I saw this on Twitter this afternoon. It was like by an account called Boston Tom. So it says, so can an attorney explain to me how a police sergeant takes video footage that is evidence from a criminal case and is in custody of is in the custody of the Canton Police Department? Said sergeant then moves this to an iCloud account that is not controlled by either Canton or the Commonwealth. He then retires. So for all the intensive purposes, is now a private citizen with no law enforcement authority whatsoever. Am I understanding correctly that he is the sole person in the possession of the link to the video evidence in a criminal trial? A retired police officer? I have questions. Who knew about this? Rafferty, Colleen Crawford, Lally? Should any of them be sanctioned for this? How does the Commonwealth even begin to explain this? And how will the court even remotely allow anything on this video to appear in a courtroom? I love that point.
Well, I'm looking at my Twitter right now to make sure that I follow, and I do, someone with such learned observations because I'm assuming Boston Tom is a male, although I'm starting to also learn from some newfound attention on X that some people may sound like they're one gender and are another. With that said, he's absolutely right. And people look at this and say, so wait, this is in the custody of a everyday citizen now. I want to know, I've got questions. I've got questions, but one of the things that I thought could have been decided yesterday as some type of interim solution by the judge was to call for what's called a plenary hearing. I thought she was going to have read these motion papers and heard the dispute between Brennan and AJ, like, well, I told him this and he said that. So hearing all of that and knowing that the motion papers set forth an affidavit from Mr. Erickson from Arizona saying that he had conversations with Colleen Crawford about, well, I don't know, there's nothing here, or whatever she said. I would have, if I were the judge, said, hold on, folks. I want you all in my courtroom on X date next week. Right. You bring, Erickson can appear by Zoom because Karen's paid for enough. He can appear by Zoom. I want Colleen Crawford in my courtroom. I want you, Brennan, and or you, Lally, which I think Lally is a scapegoat on this issue and others. And I want to start asking questions because it is self-evident right now. There was a misstep, and I think as Emily Baker said something last week, she said something like, my patience for coincidences is running out, or it hath run out.
Yeah.
No way. And there's no chain of custody. Who's messing with this? And what form is this data in? I have nothing but sympathy for Karen's defense team and always Karen and her family. But as a lawyer, I have sympathy for her defense team because good lawyers can really only do so much when they're faced with this type of absolute sham of a prosecution and the this gamesmanship. Right. And they're just trying to do their best reactive lawyering and make good arguments, and then you get an order denying your motion. So very frustrating to watch it. It is.
It's nothing that has been straight in this case all along, and it just gets worse and worse as more things come out. And I just don't get it. I really hope this jury, this time around gets it. That's really what we need. All right, let's get back to AJ here.
Videos from January 29th, 2022, 2.5 years later. And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And literally, while we're asking that question and while we're pondering that question, a couple of days ago,
I have a task for the audience. Okay. I have a task for the audience right now because the only thing that I can find it on is Scribed, and you got to be a subscription holder of that because you can only look at it really quick and then they blur it out. I need a copy of the Karen Reed probable cause affidavit, the first one. Looking on the justice page, I've had a hard time finding it. I need that. It's like a 29-page document. If someone can email that to me, and I'll drop my email in the chat, and just let me know that you have emailed it, because I want to look through that. I'm telling you, I think it was 3 days until the SUV was actually processed after it was towed from Dighton to the Canton Police Department. But that's my email. Let's talk live podcast at gmail.com. If someone can find that for me and email it to me, the original probable cause affidavit, because I want to make sure I'm correct on this. But I remember it was like 3 days, so it was actually processed. All right, let's get back to
getting yet more videos, scraps, piecemeal. We got another sallyport video just a few days ago. This one showing the Lexus backing into the sallyport from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled.
Masterful.
By continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out. You can have your expert come out, meet us at Canton. We'll provide the DVR, have him look at it. He can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in the in his opposition,
Brian, you're getting some chats. They have some questions for you about what you're looking for.
So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault. We didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR?
You know everything, AJ.
I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th.
That's what I wanted to hear, because I had this in my, and when I was at work today, I kept going, gee, we know about that 1:30 call. If there's any video of that, but bam, oh, there is. And I can't wait to see it when they present it in court.
I actually might consume alcohol that day when that testimony, I'm not much of a drinker, but I might actually do that the day that he is cross-examined on that. And yeah, there is evidence, and just notice what AJ says here. And I see the subtlety of it. He is not saying, yeah, now we got this video and this may very well prove to be exculpatory. No, he says it is exculpatory. And I understand lawyers can be hyperbolic. Lawyers were paid to make arguments. But no lawyer is really going to no ethical lawyer, which I think AJ is going to put their neck out and make such an affirmative statement about something being exculpatory in such a declarative way, then if they knew that they were just kind of making an argument there. So that motion to dismiss, which I guess is due the 11th for now, unless AJ's application to extend that gets granted, that's going to be absolute a Super Bowl, a World Series, to pick your favorite hobby. That's what it's going to be to me to read it. But yeah, that's what I was waiting for too.
And it's like funny, you go back to Karen Reed 1.0, and it was just like the mouth drop moment when Higgins is on the stand, and then all of a sudden they're like, his lawyer comes up, and you're like, what is going on here? Like, it was just like, what is going on? And
oh, sorry, Brian, go ahead.
No, it was just kind of a jaw-dropping moment in that case, and you're like, he has a lawyer there? Like, what is going on? And we hear about this proffer, and I'm like, dude, this is so shady, bro. Like,
I gotta ask you just a couple questions, right?
Yeah.
So first, because I don't watch every stream of every creator.
Sure.
But you are aware of the alleged Higgins phone into JFK, the JFK show?
Yes.
Okay, the decorated dude.
Yes, decorated dude.
Not Kevin. Higgins said he's Kevin from
South Boston. No one says South Boston.
Yeah. Even I know that, and I just visit Boston like 2 or 3 times a year. But with that said, like,
excuse me,
do you believe that was him?
Yes.
In your opinion, okay.
100%.
That
did you see the microdots analytic video that he literally put? Mary, thank you. I got the PCA. Thank you. But they literally backed his voice from the trial to that call. I mean, just matches up perfectly.
Have you met microdots? I'm sure you have.
Yes. Oh yeah.
We
are friends.
When you ever cross paths with him, can you please just pass along my regards? It's magic. And I did see that video, and he makes me feel dumber and dumber every single day. But the other thing I thought was interesting about Higgins' testimony previously was that when he was going to be questioned about his little jaunt to the federal kiosk at the Canton PD, which, I still don't understand why Higgins has an office at the Canton PD. But
that's weird.
Holding that aside, when his lawyer says, I can talk to my client in 10 seconds about this, and, in this bravado. But at the same time, the prosecution is trying to maintain that 22 seconds is not long enough to have a conversation. But 10 seconds between a lawyer and client on a potential charge that might put you in prison, 10 seconds is enough. I digress. Bring it, AJ.
Real quick, and here it is. The black Lexus SUV was seized from the driveway of the defendant's parents' home in Dighton on January 29th as well. The vehicle was then transported via a tow to the Canton Police Department. On February 1st, members of the Mass State Police Crime Scene Service Section, Crime Lab chemist, and Trooper Joseph Paul of the Massachusetts State Police Collision Analyst Reconstruction Section responded to the department January 29th. And they didn't show up in Canton to process that vehicle until the 1st. 3 days.
I'm going to take my new microphone and say, Karen Reed's defense. Please focus on that, please.
3 days.
Oh my God. And
yeah,
that's ridiculous. Even if they didn't think anything about like a murder, which, she wasn't charged in enhanced charges till later, but they presumably knew within hours that day that it was an alleged hit and run, and 3 days passed before they processed the vehicle. You know how much stuff can get compromised just from a biological nature?
How about they start smashing some light and kind of bringing that and throwing it around everywhere?
And I think AJ gets into it,
Yeah.
and maybe this is it. Things kind of jumble in my brain
Okay.
sometimes, but when he talks about the video of the vehicle being backed into, or I forget if it's pulled into or backed into the
Yeah.
sallyport,
Pulled.
which is causing all of us to say, well, wait a minute, like we all had questions before because the video that was inverted showed snow on the ground. People are like, where did that come from? But also, I remember when he made his statement, or when it came out in a filing about there's video with the car coming from a different approach into that sallyport, my first reaction was, wait a minute, that's not the angle that the video showed. So
Yeah.
there must be this video out there. I can't wait to see this. It's not going to help the prosecution. So right now, what you're all seeing, besides good lawyering from the defense, bad lawyering from the Commonwealth, you're also seeing posturing. People, like lawyers, tend to kind of mark their territory and make themselves, self-aggrandize themselves. And I think that's what Brennan is doing to justify his very high paycheck, if you believe the recent posts about what he's been paid, beyond $75,000. And I think he is really trying to hide the fact that he was handed a pile of what as a case, and he's pot committed. He can't back out now.
Right.
For
Yep,
now.
I agree. All right, let's hear AJ
On
more.
his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr.
All right, let me just answer this, because this is like the biggest controversy inside the chat right now. Yes, I am experimenting with turning ads on during the live. Sorry. Okay, I'm experimenting. We have an option that we can do that. If you're a premium member, you won't see ads. We can turn them on aggressively. We could put them on conservatively, or we can put them at the bare minimum. I had them on conservative. It seemed like it was bothering people, so I brought it down to the lowest level right now. So you may get an ad during the live show. I'm just experimenting with it right now. I just want to see what is happening. If it's that bothersome, I can turn them off. But I wanted to experiment tonight. All right, we'll keep playing through this.
Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury. I'm sorry, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence. And
Yes,
really
it
evidence,
is.
And it was withheld in its entirety during the first trial and for the last 3 years. And it's against that. The reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Ms. Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days. What?
Oh,
How
sorry,
could that
Brian.
possibly be?
That's a load of crap.
Yeah.
They changed the settings, and I dare say that those settings were recently changed to overwrite. And there's probably a way for Mr. Erickson or some other digital or forensic computer expert to tell when the settings to overwrite were set. And Melanie Little has someone who kind of gives her stream information. She had said something to the effect of, there's one of her members of her chat says she works in a similar setup at a different police station, I believe, in Massachusetts, I believe. And there's a way to put things on like a hold, a litigation hold, so they won't overwrite. That can be done with these types of systems.
But that goes back to Yanetti's preservation.
Yep.
I mean, it should have been preserved then.
Yes. And we
you know,
as
in that motion. But now they're going to, I know Brennan's going to argue here in a little bit, like, well, they didn't say video.
yeah, like, I'm sorry, if you have to split hairs
To
like that,
preserve all evidence.
like and this stuff is going, I'm telling you, this little stupid, well, they didn't say this or they didn't do that. That type of foolish argument and manner of speech, although you don't argue evidentiary issues before a jury, this type of approach is not going to play well before a jury. And the same applies with, you know, how you're treating your more seasoned experts, if you're disrespecting, you know, some people who are a little bit older, if you're throwing documents on the stand and walking away and having them read it, if you're referring to some as so-called experts, if you're referring to others as having personal asides. I mean, not once in almost 25 years of practice have I ever heard an expert witness say something like, well, I'm really offended by that question. And I mean, it was an offensive question. So this is not going to correlate well. But go ahead, AJ. Let's hear more magic.
Let's do this too. Going forward, let's not hear about ads anymore in the chat. Let's just drop it. It's so goofy. Let's concentrate back on Karen Reed's case. Oh, and by the way, her defense link is pinned to the top of the chat. If you would like, and it would be great to make a donation towards her defense. I would encourage that, please. All right, let's go on with AJ.
So the expert calls me. Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech expert. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access.
Thanks, Debbie.
Whose digital fingerprints were on that DVR. Who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well. There is no
By the way, they would have had a
footage.
log,
You get no log.
even if it got overwritten. I'm sorry to,
No, I mean-
I'm still learning if my voice can be heard
Oh,
over
it's
video.
fine. I mean,
When you stream and I'm your audience,
Yeah.
Brian, I hear you chatting over videos and it's so seamless. But they would have had a log, even if it was overwritten. But this was intentional. And I did see someone post in your chat, not about ads, but I saw someone post that, you know, the preservation order had mentioned a turret videos or police turret videos is actually, I guess I can scroll up. That the preservation order mentioned the police station. It's a PIER, P-I-E-R. Thanks for your comment. It did mention turret videos, which is a type of video or location at police stations, from what I've learned from creators. But the order itself also mentioned to preserve all evidence. And even if it didn't, it doesn't have to say any of it. And, you know, the prosecution doesn't get to pick and choose what it does or does not produce. I mentioned this on another stream recently. If anyone wants to see a good example of how it should have worked when there's a failure to provide exculpatory or inculpatory or impeachment-based evidence, watch the last hour to 2 hours of the Alec Baldwin trial in New
That's
Mexico.
wild.
And Judge Summers out there, and shout out to Peter Tragos. He actually did a nice recap of what the absolute devolution of how that case completely imploded after a jury was sworn and jeopardy attached, because of a special prosecutor who coincidentally his last name was Morrissey, completely mishandled evidence in that case. That judge had the bravery, knowledge, and confidence and temerity, to use one of Bettero's words, to dismiss that case because of egregious misconduct. That's how it should have been done. And that's why people like me who know better, I get real frustrated when we see this happening.
I just want to answer this. Septic Hank the Tank says, Brian's definitely not a grifter. was just saying he turned out the odds, meaning he won't generate any money tomorrow. They're going to call him a grifter on the Hater channel. Well, here's the funny thing is, I just want to get to this really quick. Here's the funny thing about it. I've probably donated out of money that have come through my YouTube channel, and I have the receipts to back it up, probably close to $10,000 to Karen Reed's defense fund. Okay. I took out two billboards for Enrique Delgado Garcia at $3,500 a piece, money that I generated through my YouTube channel. So I gave all that back to my community to help them. So if you want to call me a grifter, have at it, because I know I'm definitely not a grifter. Okay. So we'll end that conversation. Also, I just want to get to this. Annie, Elisa, thank you so much for the $20 on Cash App. It helps keep the lights on here in the studio. All right, let's get to AJ.
This was a
Yeah.
complete and utter waste of time. According to the Commonwealth, that system, as I said,
And listen, I don't like to talk about money and all that goofy stuff, but I'm making my point. If they want to go ahead and challenge me on that, I'll show you the receipts.
Yeah.
Okay.
And
All
also,
day.
and Brian, I really love when you make your chat raiser. You have chat raisers and post what you give percentages
Sure.
of your chats to Karen Reed's fund. Like the fact is, and we could step off of it, or you don't have to. It's your channel, but the amount of times that people who don't support the Free Karen Reed movement like to use a really large word that they don't understand, grifter.
Yeah.
They like to say that because it makes them sound smart. And for all of us, we all know better, because it actually makes them sound like a bunch of idiots, in my opinion.
No, it really does. And just to touch on this a little bit, you don't think that Ted Daniel doesn't get paid? I mean, he's going to be doing an interview with Karen Reed on Super Bowl Sunday at 6:30. You don't think he got paid? You don't think that, I don't know, who's another, Megyn Kelly gets paid to talk about the news and murder trials and whatever comes across their plate? You don't think that, Fox News and CNN makes ad revenue from their channel? I have every right to do what I'm doing, and I've given back to my community and help my community and help people out. I don't need to explain myself to anybody at all. But anyway, this is just so pointless to talk about this goofy stuff. But the most important thing here is that we're giving Karen Reed positive press. And if it wasn't for creators like ourselves and the people that are in this movement and this wonderful defense team, there would be no positivity for Karen Reed. This case wouldn't be as out there as it is. I mean, AJ himself, when I had the opportunity to go in and sit in during that one day at trial, said, "You all have made a difference, because Karen Reed would not be supported if it wasn't for all of the people like yourselves." And I truly believe in that. I really do. And every new person that we can bring into this movement to support in a positive way, to get that message and tell her story and have that chain, the train kind of roll down the tracks of bringing new people in and supporting, all the more better in all of this.
Hear, hear.
All right. What's that?
I said, hear, hear.
Yeah.
You're absolutely right.
30 days.
For AJ.
So by February 28th, I counted them. By February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then, to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd of Miss Reed's money, and fly an expert out to Canton for absolutely no reason. Zero.
Yeah.
The 30-day override protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it. We knew it. Mr. Brennan knew it. Everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to.
Real quick, Nan, I have a question. $20 super chat from Sarah. She's asking you a question. Only Nan, is it only on TV when there is no chain of custody evidence gets thrown out? How can this be trusted? Hang on. There's a little bit longer than. Let me get this up. Make sure I'm saying this correctly for you. Let's see. What is her question? Her question is, let's see.
I might also be able to surmise where she
It
was
says,
going.
only Nan, is it only on TV when there is no chain of custody evidence gets thrown out? How can this be trusted? Also, can they have taken her SUV and phone without search warrants? Is it because she gave it to them before warrants?
Wow. Okay. So show me a little mercy, because I'm better at reading questions than hearing them. But with that said, chain of custody cases where there is, breaks in chain of custody or mishandling of evidence, or, a clear showing that there's breaks in the chain of custody, those types of cases, at least in the jurisdictions I practice in, routinely would be dismissed. If the lawyers can show on its face that the evidence isn't authentic or cannot be authenticated, then there is no credible, reliable reason to have that as evidence at the time of trial. That's why things like hearsay don't come in, because those are out of court statements that are put into court for the truth of what they assert. But if they can't be authenticated, like, we go by best evidence rule. The best evidence should be coming into trial. That's why if someone says, well, Brian told me that, no, bring Brian into the trial. Let Brian, he's the best evidence. So those types of cases should be dismissed. And if they're not, it is fodder for cross-examination. This judge seems to, from my observation, have a very unique, and I don't mean that in a positive way, approach to how she handles objections, because lawyers would be objecting to the types of questions that get asked of witnesses on chain of custody. And right now, think about how the next trial is going to go and compare it to how trial 1.0 went. When Lally just said objection all the time, who the hell knows why he was objecting half the time? And there were chain of custody types of questions that Jackson or Yannetti were trying to ask, and the judge was routinely overruling those very sound objections. You had asked a question about her phone and some other piece of tech that she had. They would have needed warrants for those phones.
Right.
She does have at least in the jurisdictions I practice in, she does have a right to privacy in those. But my understanding from what I read was, I believe she voluntarily handed over her phone. And that's very telling to an onlooker on a true crime case like myself. Many times witnesses will voluntarily just hand over their phones. I'm not saying you should do that. You have a right to privacy, but there's nothing to hide, But at the same time, you have people like, my personal opinion, Jen McCabe, who's like, I willingly and voluntarily handed over my phone, which, by the way, I have to work on my Boston Jen McCabe accent, because every time I do it, I sound like I'm from Brooklyn. But beyond that, she's like, I willingly handed over my phone. And yeah, sure you did. After you completely deleted data, Google searches, text messages, phone calls, you curated, you curated the data in it. You deleted, apparently with the tacit knowledge of the police, text between you and your daughter, who, suddenly is now a witness in the trial, because she allegedly may have been involved in, I've heard people saying the getaway car. I've heard
Right.
people say, you know, she was up to something with Colin. She was up to something with Chloe. Insert whatever bad thing you think the daughter could allegedly have been involved in. But you have Jen McCabe saying, I willingly handed over my phone. So in theory, it's best to only hand over pieces of your personal property to law enforcement upon the production of a valid binding subpoena and or warrant, and to do that on the advice of counsel. None of this is legal advice, and please consult your local attorneys for more. I feel like in a walking ad for this stuff.
All right, let's hear a little bit more from AJ. I don't think we're going to get through this complete hearing, but what I'll
Sorry.
do is no, it's okay. And what I'll do is I'll speed up and we can hear a little bit of Brennan's reaction and kind of react to that here. We'll hear a little bit more here from AJ.
To have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork in his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account.
That's kind of
Not
scary.
on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in
Some
2025.
kind of iCloud account.
It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire.
There you go.
Ms. Reed has to pay for the fire extinguisher. And that's not fair.
He's a wordsmith.
The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right, thank you very much.
She doesn't care. Doesn't care.
But she doesn't care. And even if she does, just a word of unsolicited advice for her: take a deep breath, sit up tall, and just pretend.
Right.
Pretend to be, oh, thank you very much, Mr. Brennan. Just do it. I don't care how long you've been doing it. You're paid by taxpayer dollars. Sit up respectfully and please do your job, showing due deference to both sides.
Yeah, now we're gonna hear whiny Brennan here.
Oh, by the way, someone in the chat said, anyone know who this guest is? I'm Nan Gallagher. I'm an attorney from New Jersey and New York who's incredibly opinionated and snarky and part of the Free Karen Reed movement. Welcome. Buckle up. You're in for some fun.
I love it. All right, let's hear snarky Brennan.
He's clutching his pearls, Brian.
Yeah, he was already pissed, like turning the corner to get to the podium. Watch how quick he turns the podium, man.
He looks like he hasn't taken a shit in 4 days.
Yeah, watch this.
Right,
Watch him turn the podium. Watch. He's pissed. Look.
And now I have to tell
the
the court.
microphone out of the
It's
way.
notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they...
Not even good morning, Judge. May I? Just totally disrespectful. Can I please the court? Nothing. Just
It's like nails
like
down a
Chloe.
chalkboard.
Teeth and claws out. It's like Chloe. Teeth and claws out. Here we go.
Maybe Brennan injured the right arm.
Seriously.
And now this is a big cover up. So they bring Brennan in. He's the actual culprit.
Yeah,
he was driving the Lexus. Sorry.
We're not trying to be comical or insensitive to the situation, but
Yes, I
no, we're
agree.
just kind of joking a little bit here. All
Hired an
right.
expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information
He is
they want,
pissed.
whether it is required or not
Agreed.
required.
Agreed.
Yet, I'm standing here today, and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I
You're
stand
not
back and do
entitled
nothing,
to $75,000 of state taxpayer dollars, Brennan. Sorry.
No, it's okay. So he has to explain now because Lally fucked up so much. That's why.
I get a little punchy at, after 10 o'clock, and that's by no means an invitation for you to end this, Brian, but the punch level of my snark will escalate exponentially. I'm going to apologize right now to everyone and give you an opportunity to leave, but I think you're going to stay because you like a good, some good snark to start your weekend.
Do you have another 30 minutes or is that too long?
Oh, I do.
Okay, cool. Let's do 30 more minutes.
Yeah.
And then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you and I must tell you what happened. When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense.
Should have been turned over before the first trial.
Yeah. Try to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to
He's really insulting Yannetti there. That's what he's doing.
That is
when you're being overzealous like that, especially as an attorney, you're literally insulting him.
And by the way, and cross affidavits where two lawyers are taking contrary to positions on how things went down, extremely common where I come from. And I dare say very common in the Massachusetts area. I dare say. So for him to clutch his pearls like this, and I must tell the court what really happened.
Oh, yeah.
Jerk. Sorry.
Yeah. And Salty Sally says 0 class. And I agree.
Agreed.
And that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency and an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape.
So Hank's the good guy, right?
I wanted to do what I could to accommodate.
Sure loves himself,
Yeah,
right?
he's the good guy now.
Despite that there was no court order, no motion to preserve, I invited him to come.
This
to
is
the
what I
Canton
was
Police
talking
Department.
about before. Sorry, you can. Well, I don't want to step over his words, but he's trying to make it sound like, look at all I'm doing. Look at all I've done for them.
He's the good guy now. Yeah.
As if the judge doesn't really know any
Right.
better. Some audience members and people of the common public will, maybe not your audience, but the people of the public could look at an argument like this and say, well, look how generous Hank Brennan is. He's really going out
I
of his way
know.
to hand this stuff over. So, that's another reason why I started speaking up on this to just add to these conversations. This is unprofessional.
Super
Yeah.
unprofessional. Pierre asked, do you think it's even $10? Thank you so much for the super chat. Pierre says, do you think it's possible that Lally hasn't briefed Brennan at all?
I think it's possible. I mean, a lawyer can, like Brennan.
I think
will-
Brennan's just sit there.
Yeah, he's like, sit down, put your head
Yeah.
down. But, they have their case file. So to some degree, Brennan presumably has access to the same or similar evidence if it existed.
Right.
But with that said, a special prosecutor should be afforded an opportunity, and often is, to consult with the underlying handling prosecutor. And that does not, to me, seem to be happening here. I don't even think they greet each other when court starts.
They don't even look at each other.
Imagine how Lally feels right now. He must have been promised.
Embarrassing.
Trust me, folks, he's been promised property in Boca and, maybe a nice bump up on his pension if he just keeps his head down and, sharpens pencils, eats his cheese sandwich, if he just sits there and provides the optics that everything is copacetic here. Because think about it from a PR standpoint. If he wasn't involved at this point, if it was what happened to Lally, oh my God, he must have mishandled it. I don't think Meatball could have, by the way, excellent show on Meatball, Brian. That was the gift that kept on giving. If your audience hasn't seen Brian's stream on Meatball Morrissey, please go back. It was last night, I believe, or the night before. But
2 nights ago. Yeah.
And it was great. But, I think Meatball is, in my opinion, not able to swallow the optic that if people speculating what happened to Lally. So he's making it look like they're communing with one another. I don't think they're even talking about the weather, the Red Sox, the Celtics,
nothing,
their jock itch or anything else. Sorry, I warned you all.
And from SB, thanks for the 5. She says Hank Brennan is a douchey. I love that.
I feel seen.
All right, let's hear him whine.
I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. And so I called Attorney Jackson back, and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NPR. I had the same concern. I want all of the evidence.
I'm sure you
do.
Right.
Jinx.
I want all of the evidence. And so
all right. Septic Hank the Tank, $5. Just to be absolutely clear, I have a lot of respect for this channel, for Brian and the Free Karen Read movement. Didn't mean to strike a nerve with the G word. No, it's all good, man. It's all good. Don't worry about it. We welcome you here. We love you being here. I was just making a simple point. I've heard it all. They can attack me all they want. And the best thing to do is just don't give it any wind. Just turn your head. You know that you're doing the most best, honest thing in this movement. And that is supporting Karen in any way that you can. If you can't monetarily help, you can just make a sign and stand out in a corner with a sign that says Free Karen Read. And that is the best advertisement to point people in the right direction and get them educated on what is going on here in Norfolk County. There's no expectation. We just want people to be involved. We want people to support Karen in a positive way. And if you can contribute, we, do it in the way that makes, that is, what is the word I'm looking for? Do it in a way that is, I don't want to say safe for you, but in the way that you can do it, if that makes any sense.
Just a quick comment. First,
sure.
septic Hank the Tank. Love your handle. Second, I totally understand where you're coming from with that recent chat that you just put up. Mm-hmm. I think Brian and I and others have him much longer than me. we've been experiencing some friction, me on a very acute scale in a very short period of time, and I don't have a channel, nor do I want one.
Mhm.
You know, you didn't strike a chord. It's just when people who don't support this movement in whatever way, monetarily or boots on the ground, or just tell a friend, make people more aware. Those people who don't feel the same way, instead of just disagreeing, they resort to using that G word. So it's a little, it's a trigger word, I suppose. The other thing I was going to mention is as far as your handle is concerned, that's probably one of the funniest that I've seen.
You know, I look at the reverse side of it. Okay, those the channels that are opposite of us, right?
Yeah.
And you all know that what channels there are. Okay, so I'm not allowed to take a super chat, or I'm not allowed to make any ad revenue money, but they are.
Yeah.
What are they contributing to? They haven't turned any money over to whatever a foundation or whatever it may be. So
Right.
they're allowed to take all their money, but I'm a grifter.
Yeah,
Doesn't
like
make any
they're.
sense.
It's so interesting, and they're not, as far as I'm aware, those
They're
whatever
not contributing to anything.
to the O'Keefe,
Right. Whatever it may
orphan
be.
children, or to a
Exactly.
cause, or
Right.
to the Police Benevolent
No.
Association. Nothing.
Right.
It's a trigger word. I'm seeing it in a very short time period.
Yeah.
I am generally unliked by many in a short time. But anyway, Hank the Tank, which I love, and I love speculating. Are you man or woman, or But anyway, I love your candor. Keep showing up.
Exactly. All right, let's keep
Expressed
going here.
concern.
Let's listen to Hanky.
I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me,
Should have known.
sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was,
Who
it doesn't matter.
cares?
Whoever they send, let them look at it.
Let them eat bread.
And so
Let
when they
them
did,
drink
not
wine.
surprisingly, the information had been overwritten. Now, while there was a 30-day overwrite on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days.
See, I
do know that there was
believe.
materials on that DVR, MVR back in July of 2024. And I know that from a report that was generated by the Commonwealth and given to the defense. So they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear. I was very uncertain about what would be on there since I never looked at it.
Thank you so
After I
much,
learned there was no
Hanky.
information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras. I spoke to personnel and I spoke to the retired individual.
Such a good guy.
And,
I
responsible
mean,
for providing
All these
maybe,
accommodations,
video warrant
man.
requests. And when I
yeah,
spoke to him,
like maybe
told me
he
in
should run for
conversation that he would
prosecutor.
routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I
I
could.
wasn't going to lure them back to Canton. Real quick, let's get to this. Lee Baker, $10. Says the relationship between Brennan and Lally is serious tea. Lally's collecting a paycheck doing nothing. The optics do not look good. P.S. I like snark and sailor words. Many streamers have ads.
You
All
are
right.
in the right place, my girl.
Here you go.
By the way, just a point while you stopped, your
Yeah.
if anyone doesn't follow, if anyone is on X and supports the Karen Reed movement, and you're not following Olivia Lambeau, who's so learned on the
Is a must.
intricacies of this
Yeah.
stuff, you should, because she absolutely drew a lot of inferences away from Brennan's arguments. Where he at one point says, I never said the video was going to be there. And then, in the affidavit, he says one thing. In the oral argument, he makes it sound like, well, I never said it would still be there.
Right.
So if you really start getting ethereal with how deep this conspiracy goes, which I try not to, I'm very like, it's got to be right on its surface for it to grab me. She goes deep, peels away the layers of the onion like a surgeon. And I encourage you to read her latest tweets concerning Brennan's presentation, because she sums it up better than I ever will.
Yeah, another one to look at on Twitter that's really good at kind of breaking things down is Sleuthy Goosey.
Yes.
I've been following her for probably well over 4 years, because when was the Coburg? Coburg was about 4 years ago,
Yep.
3 years ago, 3.5. I've been following her. She's really great.
And I learned about her from all of you content creators.
Mm.
Like, I've heard you guys say, what does Sleuthy have to
Yeah,
say
she's
about
great.
this stuff?
She's
Yeah.
really good. All right, let's hear Hanky.
Helpful as I could.
Hanky.
Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they had already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file.
So much.
So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years. The
I
defense
can't.
was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause.
How
I can't.
How could you ever trust someone taking a video, putting it on an iCloud account, and then you're going to go there and download it and then give it to the defense?
Yeah. But
in Boston Tom's tweet, how is this even possible that someone that's a retired sergeant, that's not even a police officer anymore, has very important evidence in a criminal trial at their house, and they have access to that? That's mind-blowing, man.
They've got access to it, and also not a techie, but how do we know that iCloud is even secure, that others don't have access to it? And I thought you were going to say, I gotta stand this way of the teddy bear. I love it. I thought you were going to say, how can you even trust a lawyer? And I say this as a lawyer.
Excuse me.
A lawyer just looked a judge in the face. This is my opinion. He just looked a judge in the face, standing next to two attorneys who he's been opposing for months now, saying the defense waited 3 years. They didn't wait 3 years. And they, this isn't just, we didn't know that video existed, so we didn't ask. No, they knew there was video. They've been asking for video. They knew it. Even the officers were referencing video in some of their testimony, and they get a video. It's inverted. Like, the defense has done everything right. Like, that's what I was saying before. They're just banging their heads on a desk saying, what is going on here? And I now know from the two things what I need to know about Brennan. He didn't greet his adversaries when he went into court. He doesn't do that, which is really unprofessional, in my opinion.
Doesn't greet the judge.
Doesn't greet the judge. And then he'll make an argument like this, a completely disingenuous argument.
Yeah.
So
I agree. Let's because we got about 10 more minutes here. I want to speed up and listen to a little bit of Judge Bev, kind of a little bit of the back and forth here. Let's go to about 103. I think we're going to get some of it. And I want to get that when she goes, we've got to get this trial started on April 1st. Like, she is dead set on getting this started.
Yeah. Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from there, I believe that upon review and analysis, those some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now.
Yeah.
I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think it's going to be that burdensome, although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote in one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it the last trial, the same thing, forecast, and then it's coming, it's coming. I need that motion in order to get it heard before then.
She's already made her mind up. Nan, she's
Yeah,
already made her mind
you don't
up.
even need to even argue that. Like her mind is made up. And I'm telling you right now, I agree with on another stream. Peter Tragos, the lawyer was in a chat, and he said 25% chance this case goes to trial on April 1st. And I agree with him. Not just because of the SJC pending ruling, which should come in before April 1st, towards the latter part of March, I believe it is, when the ruling is due. But in addition to that, there's way too much that has to get done. So I don't know why. I'm going to keep it G-rated. I don't know why she gets so ratcheted up about the April 1st trial date. She got to chill out.
The famous Turtle Boy word, ratchet.
Yeah, there's my homage to.
Yeah, so I had a poll that I put. Do you think this trial will start on April 1st? I just ended the poll. 735 votes. 62% says no. 37% says yes. I don't think it's going to happen on April 1st.
I voted in your poll. I'm actually sneaking in on your chat. Like, I'm not logged in through StreamYard chat, but I am logged in on my phone. And I took your poll, and I just so everyone knows, I said no. I don't think it's going to.
I don't think so either. Amanda, thank you so much for the $10. This is thank you, LTL. And I want to thank Nan for jumping back on here with me again. This has been we've had some really awesome streams together, and I hope that we can continue to do a little bit more of this.
You're my new old friend, Brian.
Yes. I'm going to keep her for about 8 more minutes. Then we'll do a final wrap up. But I want to hear a little bit more of Judge Bev, and we'll play this out here before we end here. I want to get this has to start on April 1st.
Well, it has to say. What's the extent of the information that you provided today or yesterday?
Doesn't care.
Most recent discovery?
Yes.
It was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction.
Oh, you're not calling Trooper Paul?
Yeah.
We sent it by link because it was extraordinarily large.
Okay.
Excuse me.
All right. Hey,
Does the defense anticipate evidentiary motions in this case? About time that maybe I can flip these. Do you anticipate evidentiary motions?
Wow. Yannetti almost jumped over Karen to get to him.
I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
Just a point there, Brian.
Hang on one second. Where's my cursor?
They're not expected.
They both have just committed to this judge as of yesterday that they do not foresee having to file evidentiary motions. That's like motions to preclude or exclude certain testimony. That's going to change. In fact, I believe Jackson filed something today asking for more time.
Yeah, he did.
And he basically, from what I gathered, one of the things he now has evidentiary issues because of some of what's contained in this voluminous dump that he got from Brennan. And by the way, it's what, as a litigator on criminal matters, if you know what the evidence is, which isn't supposed to change, a document dump, a voluminous dump on a retrial isn't going to ruin your day. But I bet you there has been a retooling and modification of like an significant add-on and enhancement of evidence in this case that I bet you, without seeing it right now, that AJ is probably saying, hold on a second, where is this coming from and that coming from? We should have had this. And that does affect his motion to dismiss as well.
Oh boy.
A lot.
It's a lot. There's a lot.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss.
That hurt to hear.
Yeah. She doesn't care.
Nope.
So
You
we'll
can't
hear
do
it.
these
There are no
piecemeal.
evidentiary. Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th.
That's a short time frame for Brennan as
Wait,
well.
This is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If
I
there
was
are any
thinking of
evidentiary
coming up for
motions,
that.
They must be filed by February 11th.
Jesus.
Unbelievable. Someone just wrote in your chat, she seems
And I want you
tired
to
today.
talk about
You're
whether we
either
have a project
appropriately
or the
talking
defense
about
with those
me,
witnesses. So we'll have to do both
AJW.
at the same time.
Oh, it's Bev.
Your Honor, is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us the 24th to file a motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the
Trial going.
the Commonwealth if they need until the 3rd to give them a weekend. Possible?
But also, I need weekends.
Right.
So it's not possible. So I'm giving
You know, it's interesting.
from February
I'm sorry.
11th to February
Let me,
Okay.
I got to say something. Two
Yeah.
things. One, for a little perspective for your audience, weekends are incredibly pivotal for attorneys writing briefs. They are. I've ruined many a weekend in my marriage having to do a brief all weekend. Two, judges say, well, I need my weekend too. I'm not sure what she meant, but if she was implying that she needs to read through this stuff on the weekends,
Right.
so she's prepared, that is, at least in my jurisdictions, frowned upon by our jurisdictions, that that licensees and judges who are paid by taxpayer dollars are using time outside of their, 9-to-5 jobs to
Right.
do work. So it's just a little observation for you. I don't know what her intention was, and I'm not going to criticize her. I think it was, you could have given him the weekend, Bev. You could have.
Let's see what she says.
February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
I don't know how he doesn't
Commonwealth,
tell
I'll
her
give
to.
you to the 28th.
Oh, this is interesting.
Okay.
I've never seen this. Karen has a laptop now.
I noticed that in the, I'm going to use a big word, penultimate hearing. I noticed that as
Interesting.
well. By the way, did you see, you know what, we shouldn't talk about what was on other
Oh,
laptops.
yeah. It's her
courtroom.
boy. Yeah, it
It's
was cool.
unbelievable. You should see uncivil laws breakdown of that. But anyway, she's got a laptop now. Interestingly, I want to know curiously what she's looking at.
Yeah.
Two, I think she needs to be quite careful because it does appear to be, and you would know better than I, Brian, but better than me, excuse me, that it's her friends and family and supporters behind her. But I hope there's a privacy shield on the cover of that, because you would never want someone unwittingly to take a picture of that.
Right. Absolutely.
Thank you.
See what Bev says here.
All right.
So Judge, are we taking off 218?
We're going to take 2-8. Let's keep it on now. If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been no
Yes.
date sent. I'd like to.
All right, so you were filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
the defense?
Sure.
Oh, it's an extra copy? Okay. Awesome. Thank you. May I hand this in, Your Honor?
Thank you.
Thank you, sir.
I want to say that was due the day
right.
before. So he's already late in filing it. I
All
believe I'm correct
reciprocal
on that.
discovery
He's never ready and he's always late.
Yep.
be
But he
provided by
does
March
everything
6th.
right. March 6th. Something's happening March
Yeah.
6th.
They're going to go to sidebar here in a second.
All right,
Oh, man.
thank you all.
One
Yeah. I do remember in that kind of back and forth, and I might have not started it, or it might have been a little bit, but she was like, we've got to start this on April 1st. Like she was yelling at someone about it. And she's dead set. I mean, she's dead set on this. I'm going to tell, we'll finish up with this. I've already made my mind up about the motion to dismiss. I mean, you can hear it in Bev's voice. She doesn't care. She's going to glaze over it and she's going to deny it. That's my opinion in this.
I think you're right. It's like, think about when when you're a kid and you were asking your parents if you could go to the mall or the bowling alley, and they're going to say no, but you're like, well, I got to take my shot or shoot my shot. That's the vibe I'm getting. But I am also forecasting two things. One, it's going to be a very fiery, powerful motion to dismiss with a lot to unpack. So if anyone ever, if you, Brian, if you ever want to have a discussion about it when it's filed, I'm here for you.
Of course.
Two, it is my opinion, even though I think she's going to deny it, that granting, assuming it's great arguments are presented, some will be stronger than others. Assuming it is a good, well put together motion citing tremendous Brady related issues, dismissing the case would be the path of least resistance for this case to end. Judge Bev gets out. No, while there will be quote fault or fingers pointed at the prosecution and or the police or Commonwealth, they can still maintain their plausible deniability and say, no, we disagree with what the judge said. We argued strenuously while clutching their pearls. Karen would get a win, but at what cost? Karen also would have, I don't believe, a strong likelihood of success. Let me say that differently because it's late in the evening. If I'm gonna strike the last part of what I said. Please give me grace. If the case gets dismissed on Brady grounds, I will comment when I'm less tired on a civil rights action she can file.
Yeah.
But I think the path of least resistance is for the judge to grant it. Just haven't seen the arguments yet.
Yeah. There's going to be a lot of lawsuits in this afterwards. Proctor will be one, the Commonwealth. There's going to be a lot of lawsuits in all of this, but we'll have to wait till we get there.
Stay tuned.
All right, everybody. I want to thank every single one of you that jumped in on this Friday night stream. I know it's late. I kept Nan late. I want to thank her for her time to make this accommodation. We got through some of the hearing, which was great. Great commentary back and forth. And I want to thank everybody that supported the channel this evening, all the new subscribers, the members that came in. It's been really great. And I look forward to doing more of this with Nan as this trial rolls on and these hearings roll on. And oh God, it's going to be another long one, people. Trust me. This is going to be long and it's going to be fiery. And I think that when this trial starts, there's going to be a lot of new stuff that comes out and it's going to be fiery and you're going to get all the the fireworks from Brennan, and we're going to hear a lot of Alessi, and it's going to be a wild trial.
Everybody,
Pretty wild.
please make sure that you subscribe to this channel. Brian works so hard on it. I see it now extremely firsthand for him. And if you liked the video, please like it on the way out. Like, we're just, thank you so much for all of your input. I'm getting better at contemporaneously reading your chats, and keep showing up, everybody. Just make your voices count. Tell someone who doesn't know about Karen Reed. Make that your homework. Tell somebody that doesn't know about this case what's going on up in Massachusetts, and try to make a difference. That's what I'm trying to do.
I agree. Well, that's going to end this show for tonight, this Friday night. I want to thank everybody again for hanging out, subscribing, supporting the channel. And if you made a donation to Karen Reed's Defense Fund tonight, I appreciate that. I know Nan does as well too. I'm going to hit the outro, and I will see everybody soon. We love you, and make sure to like, share, and subscribe. Good night, everybody. Have a great night. Bye-bye.